federal judge has denied Democratic presidential candidate Cenk Uyghur's request to be included on South Carolina's Democratic presidential primary ballot, despite being a naturalized citizen rather than a natural born citizen of the United States. Now, the judge rejected Uyghur's argument that the Constitution's 14th Amendment overrode the natural born citizen clause of the Constitution. But I thought that there were some exchanges in this court proceeding that are worth knowing about, because to me, this is actually the first indication that there is a possibility that as Uyghur, appeals this, and he is appealing this decision, the appeals court might have a different opinion here. So let me make my case. Here's what happened. Now, the 14th Amendment, which states all persons born or naturalized in the United States are citizens of the United States, and that all citizens have a right to equal protection under the law, created one single undiluted citizenship, and repealed the obsolete vestigial, I can't say that word, sorry about that, words that linger in the natural born citizen clause. And that's according to Uyghur's attorney, his name is Dwayne Sam. That's what he said in his oral argument. So that's the heart of the argument that Uyghur is making, right? Now, the lawyer also argued that the state party, meaning the state's Democratic Party, which is keeping Cenk off the ballot, discriminated against Uyghur based on national origin, a protected class like race or gender, when it rejected him from the ballot. But the US district judge, his name is Joseph Anderson, ruled from the bench on January 10th that he was not convinced that the equal protection clause of the Constitution or the due process rights afforded in the Fifth Amendment effectively repealed the constitutional requirement that a president or the president be a natural born citizen. And so for anyone who doesn't know, Cenk Uyghur was not born in the United States, which is why he's a naturalized citizen. He was born in Istanbul, Turkey, to Turkish parents. And so he told reporters after the ruling that he does plan to appeal to the Fourth US Circuit Court of Appeals. And he has been accepted on ballots in other states, 6 other states for that matter. By the way, South Carolina did something super shady where, in order to appear on a ballot, you have to pay for it. I didn't even know this. This is yet another example of how you need to be a wealthy individual or fundraise like crazy in order to run for president. And it's just, I find it to be incredibly undemocratic. But there are people who believe in what Cenk is doing. They've been donating to him small dollar donations, and he's been using it to make this case and also to run because he really does want a primary challenge to Joe Biden. But basically, his campaign paid $25,000 to do the application to appear on that ballot. And the state's Democratic Party just took the money and they won't return it. Like, that's insane. Anyway, during oral arguments, the judge, Anderson, called the legislative history of the amendment basically inconclusive. Okay, so let's just stop there. He's basically saying the interpretation of this amendment and how it applies to the case that Uyghur's bringing forth here, it's kind of inconclusive. So that's where I see a little sliver of hope, to be quite frank. But it's a sliver. It is a sliver. And clearly, since Cenk is planning on repealing or appealing this, he sees some hope in pursuing the appeals. But nonetheless, let me continue. But said that specific language, like in the natural born citizen clause, should be given more weight than general language, like in the 14th Amendment. And finding that a legal text implicitly repeals another is generally discouraged. That cuts against you, Anderson told Uyghur's attorney, Sam. There's also some precedent that the judge turned to in making his decision, like a 2012 Colorado federal court decision that found that a Guyana-born naturalized citizen could not be barred from, could be barred, my apologies, could be barred from the Democratic primary ballot. And that ruling was affirmed in an appeals court decision authored by then Judge Neil Gorsuch, who's now a Supreme Court justice. So that precedent is also working against Cenk Uygur here. But interestingly enough, an attorney for the state's Democratic Party tried to sidestep the 14th Amendment argument, which I thought was interesting. An attorney for the state party argued that the Democratic Party has a First Amendment right of association and is free to choose from or choose whom they allow to participate in their primaries. Quote, "We get to say who we want in our primary." Richard Hurick, the attorney for the state party, told the judge, this is so gross. The Democratic Party is not stopping Uygur from running for president in the general election, he said. What does that even mean? I mean, you're not allowing him to participate in the Democratic primaries. He's running as a Democratic candidate. And so anyway, he knows what he's doing. He knows what he's saying, but just absorb the admission there. The admission is, no. We call the shots. So is it really a democracy when a bunch of Democratic officials in a state decide whether or not a Democratic candidate will even appear on the ballot? Because remember, they're not even addressing, they're sidestepping Uygur's 14th Amendment argument. They're not even addressing that, which I thought was interesting. Instead, they're arguing, well, we have a First Amendment right to say no to Uygur because we just don't want him. How about that? Which is, I think, a pretty gross thing to say. And what I thought was interesting was that Anderson, the judge, seemed pretty skeptical of that First Amendment argument, and even mentioned a 1944 Supreme Court ruling that stopped the Texas Democratic Party from excluding Black people from voting in their primaries. At that point, the lawyer representing the Democratic Party in South Carolina said that the party cannot and would not discriminate against a candidate based on race or gender, but it could exclude someone like Uygur because they are not constitutionally qualified. Okay, but whether he's constitutionally qualified or not is currently being adjudicated. So you could put him on the ballot and then see what happens after this case is adjudicated, but they're refusing to do it. 6 other states have chosen to put Uygur on the ballot, and will change course if the court case plays out and indicates that no, the Constitution does not give you the right to run for president as a naturalized citizen. Now, in his brief oral ruling from the bench, Anderson indicated that his decision turned on the 14th Amendment question at the heart of this case. And he was not at all providing credibility to the First Amendment argument that the state's Democratic Party was making. And so the judge said it was a strong assertion by the Democratic Party that they definitely, I'm sorry, this is actually a statement from Cenk. It was a strong assertion by the Democratic Party that they definitely want to discriminate based on national origin, Uygur told reporters. It's good for 24 million citizens in America to know the Democratic Party does not want you and does not respect you, he said, referring to the number of naturalized citizens. And in response to that, the lawyer for the South Carolina Democratic Party said, quote, "We did not say, oh, Mr. Uygur's a foreigner. We don't want a foreigner in our election. The goal was we don't want to step into a controversy with you." And so the controversy is his naturalized citizen status. They think that that is going to waste their time and potentially waste delegates if he appears on the ballot and actually gets enough votes. And so that is the argument that they're making, but we'll see how this plays out as Cenk appeals this to the Court of Appeals.
If you enjoyed this video, that's because of our members. They make us independent, they make us strong, and they make us honest. Become a member today by hitting the join button below.